Welcome to the HCBA Power Hour. My name is Dan Mulka. I'm the Executive Director of the Heritage Corridor Business Alliance, and I'm with Mark Berardi of Berardi and Associates. Mark's a lawyer here in the Homer Glen area, and he's actually a resident at the same time. His focus is residential and commercial real estate planning, such as like wills and trusts, estate administration, probate, guardianship, and bankruptcy. So I'd like to welcome Mark to the Power Hour. Thank you so much for taking the time with us.
Hey, thank you, Dan. Yeah, I'm Mark Berardi. It's really me. No. But yes, I do. I've lived in Homer Glen since 2010. And I grew up in Lamont, but it was 131st and Bell, so it was basically. I went to Joliet Catholic. We've got two girls, two 7-year-old, 5-year-old. We're in town, and law school, the whole whatever, who cares? So, but I'm a licensed attorney, so trust me on that. But
but one of the things too, Mark is local. So
yeah,
if you're listening to this locally, this is definitely somebody you may run into and you may see around in the streets. And if you're listening to us from far away, you can give them a call.
Yes, you might know me best as the guy with the giant red Jeep. So if you see that at my office, I'm here. Pretty conspicuous. So, but yeah, I am also licensed in the state of Florida. I took the bar exam down there in July of last year, licensed down there, and I'm pending on Indiana. So kind of just following where everybody's moving, but.
Oh yeah. And it's a good reason to take a Florida vacation. You can call it work.
It's a write-off. That's right. There's another tip for you.
I'm going to write that one down.
Yeah.
Move the Lamont and Homer Glen Chamber to Florida.
There you go. But yeah, so I'm basically talking about just some estate planning basics. There's a lot of, you hear a lot of buzzwords out there, and we're going to just kind of simply break it down the best way I can, and we can build up on that with more advanced topics later on, the business succession planning and things like that. So right off the bat, estate planning, what is it? I mean, normally it can be as simple as a will. It can be as complex as a trust, a will, powers of attorney for healthcare, power of attorney for property, all the stuff, and life insurance trusts and this and that and the other. It can be simple, it can be complicated, but at the basic premise is, what do we do with your stuff when you're not here anymore? If you don't have a will, the state of Illinois has one for you. It's called the intestate statute. So basically, if you pass away, your family has to go to probate court. You're going to prove to the judge who your heirs are, which would generally be your surviving spouse and your children. It gets complicated if people have predeceased you. Another topic. If you have a will, that's another thing. Why do I have to go to probate court if I have a will? A will is considered an ambulatory document. It means that you can revoke it all the way right up to the date of the moment of your death. You can tear it up. So we have to be able to provide it to the court to prove it up. We say, hey, judge, here's what we believe to be the last will. We open it up to other interested parties coming in to contest the validity of it. If there's no contest, great. Somebody's named the executor, and off you go. It's fine. Probate court is fine. It can serve a function if you've got creditor issues that we want to clear up and have like a very methodical approach to breaking down the estate, or if there are family members that are fighting, great, let's throw them in front of the judge. Let's just get in front of the judge and make it easy. So it's not the big boogeyman that everybody makes it out to be, but for a simple, me, my wife, my 2 kids, I pass, she gets everything, she passes, it goes to the kids. I don't need a judge involved, right? So I can name somebody to be the executor, trustee of my trust, etc., and avoid this entirely. It's not the end of the world. Again, probably costs $2 or $3 grand. You're in, the process is open for at least 6 months, sometimes a little bit longer, a few court appearances. So obviously, when you're already dealing with the death of somebody, you probably don't really want to then hire an attorney and deal with this and have to go to court. And so a lot of people are like, Mark, how do I avoid probate? Like, what do I do here? There's 2 triggers that cause you to have to go to probate. One is owning any real estate in your individual name, any real estate. And the other is if the sum of all of your other assets that don't have beneficiary designations on them exceeds $100,000 in value, you go to probate court. So what does that mean? So we don't count anything with a beneficiary on it, 401k, IRA, life insurance. not part of that calculus. What do we count? Brokerage account in your name, checking account, savings account, anything that's owned by you individually that gets added up. And if you go over 100, you have to go to probate to distribute any of those assets. Same with real estate. You could have a $10 completely worthless parcel that's a Superfund site under a power line. You're going to probate court, period. So I have a lot of people that'll have, a house here. They'll have a house we were just talking about Florida. You'll have a house in Florida. And it's fine. You can have a will. You can have a will here. You can have a will in Florida. It doesn't really matter. I don't care where your will is. The key is you've got 2 probate cases now. You're going to have to open one in Florida. You're going to have to open one in Illinois. That's 2 attorneys, 2 2 court systems, double the money. So trusts are nice because a trust allows you to avoid all of that. And you might think, well, Mark, I don't have that much money. A trust isn't that important. You may be true, but you can build on them. So oftentimes I'll have clients that are younger, getting started. They're in their, early 30s, late 20s. They're having kids. There's, hey, I got my first promotion. I got my 401k. I'm adulting now. What do I do? Well, we can create, the trust with a pour over will, with a power of attorney. We'll talk about that in a minute. And the idea is that you build on this foundation that we create. And it's important because that first signing event has to be in front of 2 uninterested witnesses, a notary. It's the whole thing that you think of when you have the will signing. You got to come to my office. We're going to do this whole thing. But the nice thing is if you want to change that trust, you want to amend the trust, you don't have to go through all that. Hey, Mark, want to change it instead of 50-50 to my kids, 60-40 and 10 grand to my girlfriend. Okay, cool. Whatever. We can do an amendment to the trust, send it to you, you sign it, notarize, throw it in the binder that I give you. We don't have to go through all the pomp and circumstance, which is nice. It's flexible. People like it because once you have it, it kind of just goes with the flow. And it travels with you. So if you leave Illinois, you move to Florida, automatically that trust will be interpreted by the state of which you're now a domiciliary. So, you don't have to, oh my God, I got to change everything. No, it just goes with you. The other thing that goes with it is a pour over will that just says, hey, anything that I own, like a car, checking account, that isn't in the name of the trust, pour it into the trust, distribute it according to the terms of the trust. So it's a very basic will, but it cleans everything up because if you die from like a personal injury case, that's going to get routed through your probate estate into your trust, which may have like limitations like my kids can't touch their money till they're age 25. It's available for their health, education, welfare, but not for their, I want to go buy a Corvette and drive to Vegas and, put it all on red. You can't do that till you're 25. And you can always change that too. So powers of attorney are another very important part of an estate plan. There's 2 types: power of attorney for property, power of attorney for healthcare. And you hear this stuff thrown about all the time. Oh, I'm POA for my mom. Cool. Couple of important things. A POA only works if the principal, so if you're the one signing that POA, you have to be alive. If you're dead, the POA doesn't exist anymore legally. Because I've had people do that. Hey, Mark, we're going to sell the house. Don't worry, I'm POA for mom. Oh, is mom alive? No, she died 2 years ago. Okay, not going to work. So that's where the trust would come in, or a will, or any number of other things that we can do. But for purposes of a POA, they're very easy to create. They're extremely important because if, God forbid, you get into a car accident, you become unconscious, you have dementia, we have to then go to court to get a guardianship for you. And that's in probate court too, but that's even more expensive because the judge will appoint somebody called a guardian ad litem, a GAL. They come into court, they come into your home, they come in and investigate everybody, who's taking care of you, what's going on, and they bill by the hour. So it gets expensive. So if you have the POA, automatically, there's usually a triggering event in there, whether it's effective immediately or effective upon a doctor's note indicating that I've lost capacity, then it's in play until I'm dead. Same with, that's power of attorney for finances. That's for, again, property, finances, transactions, paying bills, talking to creditors, talking to banks. Then you've got the power of attorney for healthcare, which is kind of self-explanatory. If you can't make a healthcare decision for yourself, somebody has to do it for you. And again, if we don't want to have to go to guardianship court, you've got a POA. Done. Easy, simple, and it cleans up a lot of problems. So even if you've got a simple estate, a house, a car, a checking account, and a couple of kids and a wife, great. There's one more way around this. If you're like, I really don't want to do a trust. Okay. If you own one piece of real estate in the state of Illinois and it's your primary residence, we can do something called a transfer on death instrument, a TODI, TODI. This is another thing you hear a lot about. Basically, it's like adding a beneficiary designation to your home. So what Illinois, in I think it was like 2012, they passed a statute that allowed these. It's a document that does not transfer actual ownership to your home, but it does get recorded with the county recorder. And all it says is, hey, my house, when I'm dead, goes to these people. That's it. It's revocable. If you sell the house, it's automatically revoked. It doesn't hold up anything because a lot of people will do that. They'll say, hey, why don't I just put my kid on? Put my kids on the house. You could do that too. You can put everybody on as a joint owner. And then as people die, whoever's left will own the home. The problem with that is if you transfer ownership of the piece of real estate to other people, you're now subject to their debts. So you're all deemed as co-owners to be 100% owners of the property, generally speaking, right? Even though you're not. It's kind of like a legal fiction. But ultimately, if my daughter is on the house with me and she's getting sued or getting divorced, theoretically, my house is now in play for her debts, for her divorce, et cetera, et cetera. I've seen it happen. It does happen. It's the law of unintended consequences. You think it's the easy route, but it ends up causing more problems. When you could just as simply do a transfer on death instrument, you're recording a document and it has the same effect. The transfer of the ownership doesn't happen until after you die. So you still do whatever you want. If you needed to get a home equity loan or whatever, you don't need your daughter to come off the title or, accede to the recording of a mortgage on the house, stuff like that. So makes it easier. Again, and we kind of just scale it depending on the complexity of the client, what they need, what they want, what they're willing to do. And again, just right off the bat, anybody that has property in another state, you're getting a trust, period. You have to. It's just such a simple fix for a very expensive problem. So kind of threw a lot out there. So I don't know, Dan, if you had any bits that you want to pick apart and we can kind of talk from there.
Well, I wanted to mention too, because I know you mentioned kind of situations that involve multi-state, and who knows if somebody, and this is my goal to have houses in every state, things like that. But for example, you mentioned, and I forgot the term that you used, but the where you primarily live.
Yeah, domicile.
Domicile. Okay. So what happens if it happens to be 50-50?
So there's a couple of tests, but basically we look at where were you primarily 6 months in a day, right? And I mean, so there's a couple ways to look at it. The court wants to know, what is your domicile? Your domicile is physically located at a place with the intent to stay. So they're going to look at a lot of factors again. What state is your driver's license? Where are the majority of your assets? What is your main ad? So for example, here's a good example. For me, I've got the law office in Illinois. I've got the law office in Florida. I've got a house in Illinois. I've got a house in Florida. I've got an Illinois driver's license. My plates on my cars are Illinois. I vote in Illinois. The majority of my income comes from Illinois. My kids go to school in Illinois. Even if I were somehow to spend 5 months and 28 days in Florida, I'm still an Illinois domiciliary, period. Now, on the flip side, if my kids are not in school anymore and I'm spending that 6 months in a day in Florida and I've got, voting in Florida, my mail goes to Florida, all my bills, it kind of hedges the other direction. Ultimately, really doesn't matter that much. Here's why. The situs of the real estate, whatever state it's in, that's the law that governs it. So even if you never even go to Florida, but you have a VRBO or an Airbnb down there, that particular property is going to be governed by Florida law because it's real estate of Florida, and everything else would be handled in Illinois. But really, that's the benefit of it, is that you're not having to make that calculus when you're traveling or when you're, like you said, every other month you're in a different state living in one of your palaces. You don't have to do it. You don't have to worry about it. It's just, all right, we'll figure it out. And again, ultimately, it's just a matter of if you've got family members that are cooperative, great. And that's the key, is like naming if you've got minor children like me, naming an appropriate guardian for your kids. Okay, right now it's my parents, but if they're gone, Who am I naming? I don't know. And that's a difficult thing to decide on. Same with trustees. They're incredibly important. Now, again, if my kids are all adults and they don't have drug problems, this, that, and the other, great. It doesn't really matter. One of the kids can be a trustee that can cut the checks. Who cares? But if my kids are minors, I might want maybe one of my parents to step in as trustee to be the discretionary decision maker for, okay, yeah, you're going to college. We can buy you a Honda, Accord or a Honda Civic, not a Corvette. Right? That's the idea. If I'm not here to help make that decision, then I've named somebody that I trust prior to my kids turning 25 or whatever age to make those decisions for them and to manage their money and make sure everything's taken care of for them. Yeah, that's critically important, especially if you start, if you're cutting people out, you need somebody that really can withstand that kind of, abuse that's going to be coming. It's not a fun job. I've done it. I've represented people that have done it. It seems like it'd be like, oh, I'm so honored that dad named me as trust. It's like being honored to dig a ditch. Like it's hard work and you're going to take a lot of abuse and it's confusing at times and there's a lot of responsibilities and there's a lot of liabilities and risk. But that's why you might want to talk to whoever you want to name as trustee because it can be quite a surprise. But important to have, important to name. Because, oh yeah, and another thing too with a trust, I forgot to mention earlier, is your beneficiaries get something called spendthrift protection. This is critically important. You don't get it as the settlor, as the creator of your trust, but your beneficiaries do. Well, Mark, what does that mean? What are you talking about? Your heirs, your beneficiaries of your trust, when they inherit that money through the trust, if they leave it in the trust, so if you can imagine like trust, and I have 3 kids now, and when me and my wife both pass, it gets split into equal thirds, 3 separate accounts in that trust. If the kids, one or all of them, leave their share in the trust, it's not subject to their creditors. So IRS, child support can get through, but IRS, if you're getting divorced for property distribution, it wouldn't be counted. If you're getting sued, if you have a levy against you, all protected. So you can file bankruptcy, get your life cleared up, and then you can go back to mom and dad's nest egg that they left for you. Now, if you start commingling the funds, if you start putting money back in, if you take it out, as soon as you take it out of that account, it's subject to your creditors like anything else. And it's just the same as like a 401k or an IRA. Those are creditor protected as well, but if you take it out, it's not creditor protected anymore. But it's nice. I mean, with a will, you don't get that. With a no will, you don't get that. With just putting my kid on the house with me, you don't get that protection. So it's a pretty powerful tool for like not that much more work. Nice flexibility, and again, some nice because this may come up, and this might be a topic later on, depending on where like tax law goes. But there's some automatic estate tax protections built into these trusts as well. So, because Illinois right now, federally, you can give away so much money. I mean, I don't know anybody that's got enough to even become taxable. That's going to change.
And
then
now,
go
I was
ahead.
going to ask you too. Can you set up possibly almost like annuity payments out of the trust?
Yeah. Oh, yeah. My father-in-law has that for some reason, and yes, he wants it paid out like invested so that it creates an income and pay out quarterly whatever the income is. Again, the nice thing too about that, yeah, you'll have to file a tax return for the trust, but as long as the trust is pushing out all of its income, the recipients of the income pay the tax on it. So the trust, though it has to report income, it's not going to pay any tax. So it's nice. It works. Again, it's a job for the trustee, but it works. Yeah.
Right. Now, how much, and I don't know if you are privy to stats or research or things like this, but is there a percentage of adults that probably do not have some sort of estate plan or anything set up yet?
I don't know like the stats, but I mean, my anecdotal evidence is I would say more often than not, the people calling me to set things up are people that are getting ready for retirement. So I mean,
That would
dice.
have been my guess too. Just all
Yeah.
of a sudden be like, I wonder if, I mean, it's hard to think about passing away when you're probably younger. I mean, I myself am in my young 40s, but I'm like, I have a 2-year-old and a 4-year-old, and starting to think about these things that, you never thought about until you had kids.
Right. Yeah, and we do that's the two blends that we got are either the younger parents like us that are like, hey, I gotta have something. Or I have the 65-year-olds that come in and they're like, yeah, the last time we had the will done was like 1983 when my daughter was born. And you're like, okay, yeah, we're gonna need to we're gonna need to update that a little bit. Yeah, but usually it's like a big life event. I notice usually too, right after Thanksgiving is when the phone calls ramp up for estate planning. Get together. Oh my God, all these people died. Aunt Becky had a problem, and blah, 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 blah. Okay, and then that's when everybody talks and everybody gets worried. But I
Mhm.
mean, it's important, whatever it takes to get you in to get this sorted out, just because, again, the law of unintended consequences comes up and you're in court for no reason and spending money for no reason or worse.
And I can't imagine I mean, I can imagine that some of these cases may just drag out for long times. You
Oh,
almost
yeah.
read about some of the papers or you see in the kind of Hollywood situations where it's just, everybody's fighting over everybody. And, it can probably get extremely messy in some cases.
Yeah, I mean, all it takes is one disgruntled person, and you're spending real hourly rates on multiple attorneys to get things sorted out. So
And then,
it gets ugly. It can get. I mean, not usually, but it certainly can. You get some kid that mom and dad didn't get along with. We've got a problem, especially when you've got, because I've had that happen too, where shortly before mom or let's say mom is the surviving spouse, shortly before her death, she starts giving everything away to the kid that understandably has been taking care of her. So you can conceptualize why she put him on the house and gave him the bank account and this and that. But the problem is the other kid who lives in, 3,000 miles away, why did mom do this? She only did it as a courtesy, so you could pay her bills. She didn't intend for you to be on that account. She didn't intend for you to keep that money. Who's going to decide that? A judge. And now mom's money is going to lawyers and court fees, and it gets ugly. So it's easier if you just set it up the way that you want. Put it in the trust. I'm putting this account in my son's name because I want him to have it. Great. Done. If the intent is clear, there's nothing to fight about. Easier said.
now, and I know too, you kind of made reference of, what is it? You have two children, but what happens if child number three comes along? Are there ways to, I'm going to apologize for probably making this very general to say, in your trust or will saying, I want to split this evenly between my surviving kids.
Yeah.
So that way, if all of a sudden, twins or triplets comes out and kind of a oopsie situation
Hmm?
and something happens, they're still covered, before you can get back to change that will or trust.
Oh, yeah. So the trust language, when I'm working with people that potentially could have more children, it automatically includes all afterborn or adopted children. So if it's afterborn meaning after we've executed this document, if you've got, again, like you said, oops, I have three more kids, automatically you have two and you add three, it goes into five, done. Um, on the flip side, if your children or whoever you name as beneficiaries predecease you. So again, let's create a mom is alive, she has two kids, one kid has a grandchild or another child and the other has no child, okay? So child A has a kid, child B doesn't. If child B were to predecease mom, die before mom, and mom doesn't update anything, automatically child B's share goes to child A, the sibling, surviving sibling. On the flip side, if child A were to predecease mom and mom never updated her trust, child A's child, so the grandchild, would take the predeceased parent's share. Or if child A had two grandkids or two children, what I mean, I'm saying grandkids because but two children, automatically child A predeceased share goes equally to those two grandkids, subject to the terms of the trust. So if they're minors and the trust says anybody under age 25 shall not inherit, blah, 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 it's subject to those rules too. So there's a lot of fail safes and automatic stuff. Like there's also like a special needs trust built into at least the trust that I create. It says like if anybody's at the time they're inheriting this asset or share of the trust are under a disability, their share is held in trust for their benefit, but the title doesn't change over to them. So for example, if you've, God forbid, you've got a grandchild that's disabled, they're getting Medicaid, they're getting public aid, federal assistance, and by inheriting $100,000 that would disqualify them from everything, this comes in to stop that from happening. Again, law of unintended consequences. You didn't actually include this kid, but because you were in a car accident with your daughter and you both died at the same time, now he's inheriting and he's going to, lose all his benefits. We can avoid that.
Okay, that's something I would have never even thought about, but I mean, there's probably a situation for everything that could happen, and knock on, hopefully, you know, nobody sees those unintended consequences, or
Oh, yeah.
like you mentioned.
Yeah.
I'm trying to think of any other questions. I don't have any off the top of my head, but let's give some contact information so that way if anybody wants to contact you directly to learn more about estate planning and kind of maybe even talk a little bit about what to expect on like a first call.
Yeah. Yeah. And that's the thing, is to dump an hour of this onto you, your head to be spinning. So it's good in small doses of, like I said, we'll build up with the basics and go from there. There's always extra add-on stuff to discuss. But yeah, my phone number is 708-942-8030. We're over where the city hall used to be, so by Pepe's on 151st-ish, just north in Bell. And my email address is mark@berardilawoffice.com, or you can just Google me, go to the website. There's a form you can fill out to reach out to me. You can call me. There's a million ways to get a hold of me. And like I said, you see the Jeep out front, I'm here. Sometimes it's here on Saturday too. So
I would say always working, but at the same time, it's kind of a good thing to be always working.
I remember being slow like 12 years ago, and that's not fun either. So
Oh no, the scramble. I mean, let alone these days, kind of that we're in. Kind of, now that you've got some clientele built, things of that nature. I mean, it's a good spot to be in, let alone too for those thinking about giving Mark a call. That shows he has the experience to kind of help you as well, because odds are whatever situation you may have, he's probably dealt with.
more often than not.
All right, so thank you so much, Mark, for being with us here on the Power Hour. We are definitely going to have him back for a topic later in maybe a month or two. So we'll kind of discuss that, and we'll definitely put it out there when we'll have him back. But make sure you stay tuned to HCBA Power Hour. Make sure you subscribe and click whatever Apple Podcast, Spotify, or whatever way you listen to us, so that way you won't miss it as well. Thank you so much, Mark, for being on. And we're going to say goodbye. My name's Dan with the HCBA, and we'll see you next time on the Power Hour.